WNAV time is 8:51, and time for tips brought to you by Byrd and Byrd LLC attorneys at law. And joining us this morning is Jessica Estes from the law office. Good morning, Jessica.
Good morning, Bill.
Hey, thanks for stopping by on the phone once again. You know, I know there's a lot of confusion about Medicaid, but what's the most common misconception?
Well, the most common misconception is that Medicaid or the nursing home will take your house. This is absolutely false. Neither the state of Maryland, which administers the Medicaid program, nor the nursing home can take your house. In fact, if you're a married couple and one of you goes to the nursing home, your house will be an exempt asset and fully protected for your spouse. If you're single, however, the state may be able to place a lien against your house, or it can file a claim against your estate when you pass away.
Well, are there ways to prevent the state from filing a claim or putting a lien on the house?
Yes, there are things you can do to prevent either of those things from happening. First, on the Medicaid application itself, you should always mark the box that you intend to return home. This is a subjective intent, so it does not matter whether you actually are able to return home. If you have indicated on the application that you intend to return home, the state cannot lien the house without first going through a process which gives you the right to appeal the decision to lien the property. Second, if the state has placed a lien on the house, then shortly before your death, your loved ones can bring you home on hospice care. If you return home before your death, the state must release the lien. And finally, if you're able to plan ahead, you will be able to do a life estate deed without powers. This means that you will own the house for and during the term of your natural life, and immediately upon your death, the house will pass to your named remaindermen, either your children, siblings, or whomever you have indicated in the deed. Not only does this protect the house from the state's lien, but because the house will pass automatically upon your death to the named remaindermen, the house will not be part of your probate estate, and thus the state of Maryland will not be able to file a claim against the house after you die.
Okay, well, Jessica, what are some of the other misconceptions about Medicaid?
One of the most common ones we hear is if you give away assets, you have to wait 5 years before you can apply for Medicaid. Again, this is absolutely false. The state of Maryland has the right to look at all of your financial records for the 5-year period immediately prior to your Medicaid application date. This is what they call the look-back period. If the state sees that you have given away assets during that 5-year period, the state will impose a penalty. The penalty is not a monetary penalty, but rather a number of months during which you will not be eligible for Medicaid benefits. You will have to privately pay the facility during that penalty period. The penalty is calculated by dividing the total amount of the gifts by the average cost of nursing home care per month in the state of Maryland. So, depending on when the gift was given, the amount of the gift, and the resulting penalty period, it might be wise to wait 5 years before applying, and then again it might not. For example, if you gave away $32,000 1 month ago, you could apply for Medicaid immediately, and the state would impose a penalty period of 4 months. After those 4 months, Medicaid would begin paying benefits. So in this case, it would not be wise to wait 60 months before applying when Medicaid would start paying in month 5.
Okay, I thought you were allowed to give away $14,000 to any number of individuals each year.
That's another misconception. That is an IRS rule. The IRS allows you to give away $14,000 to any number of individuals each year without having to report it. However, Medicaid does not. For Medicaid purposes, if you give away money in any amount, it will be deemed a gift that will be subject to penalty.
You know, I also heard that you had to spend all your money before applying for Medicaid. Now, is that really true?
No. Depending on whether you were married or single, there are many ways to preserve your assets and still qualify for Medicaid. If you're able to plan ahead, there are special types of trusts that can be set up to preserve all the assets. A married couple can preserve almost all of the assets for the community spouse by using a Medicaid-compliant annuity. And then again, there's personal care contracts that can be drawn up to allow a child or a sibling to get paid for taking care of their loved one. And then there's always the gift and return strategies that can be implemented to preserve a portion of the assets.
All right, this sounds like it's getting complicated. Now, if any of our listeners have additional questions or want to learn more about asset preservation and Medicaid, Jessica, how do they get a hold of you?
I can be reached at area code 301-464-7448 or on our website at www.byrdandbyrd.com. That's BYRDAND, BYRD.com. And as a reminder, we host an informal Medicaid workshop on Monday, August 11th from 5:30 to 7 p.m. at our offices in Bowie. The workshop is free, but space is limited to 10 people, so you should call and reserve your seat. We do these workshops on the second Monday of every month, so if you can't make the August 11th date, then we have workshops planned for September 8th and October 13th as well. And also my colleague Brian Ritter, he hosts an estate and trust seminar on Thursday, August 21st at our Prince Frederick office from 5:30 to 7 p.m.
Okay, well, a pleasure having you with us this morning, and hope to talk to you again soon.
Thanks, Bill.
That's Jessica Estes from law offices of Byrd and Byrd, elder law attorneys, lawyers with offices in Bowie and Prince Frederick, Maryland. Not just good lawyers, good counsel.